On March 31st, 2006, Taylor Conley and his friend robbed the home of Brian Swehla. They kicked in the door and shot and strangled Swehla while trying to make him open a safe. Conley forced him to his knees and took another shot, which ended his life. He was 20 years old at the time of his crime, and he received life without the possibility of parole. He believes he should be free one day and maintains a website to share his story. Now, following the Supreme Court's decision in the Monschke case, Conley moved to be resentenced. The Monschke case establishes that life without the possibility of parole for people aged 18 to 20 is unconstitutional. It does not allow the judicial discretion to consider the mitigating factors. But the resentencing court maintained Conley's life without parole sentence. Now, Conley is appealing that decision, arguing he was unjustifiably required to wear a stun gun at his resentencing hearing. He was denied the ability to be present at the hearing where they decided if he would be restrained at that hearing. He argues the life without parole for young adults is unconstitutional and that no weight was given to his rehabilitative efforts while serving his sentence. Let's take a look.
All rise. Division 2 of the Court of Appeals of the State of Washington is now in session. Acting Chief Judge Bernard Beljacek presiding. Also sitting Judge Bradley Maxa and Judge Eric Price.
Thank you very much. You may be seated. Good morning, everyone. We have you both on video here in the courtroom. Mr. LaDucer, Mr. Ellis. We have on for this morning, our only oral argument today is case number 577976, State versus Conley. You have rebuttal time, Mr. Ellis? How much?
Yes, 5 minutes.
All righty. Take it away.
Thank you, and may it please the court. My name is Jeffrey Ellis, and I am counsel for the appellant in this case, Mr. Conley. This is an appeal from a resentencing from what is commonly called the Monschke class. And I want to talk about two issues, the shackles or stun cuff issue, and also what the sentencing judge called the standard of review, essentially the presumption that life without parole remains the sentence unless mitigation justifying a durational departure could be proven. And I guess this is one of those cases where case law that occurred after the sentencing, but which applies here, either further defines what was unknown or at least undefined in case law, which is how Monschke resentencings would go and what the range was. That was decided in the Carter case. But also further define the law in terms of the use of a security device in cases where there's no jury present, the Lukey case. So let me start then with the application of the security device, the stun cuff. The use of security devices in courtrooms are prohibited without a showing of individualized imminent threat of either escape or danger or disruption in the courtroom based on facts, not supposition, because there's an unacceptable risk that the use of a security device will imply that the offender constitutes a danger to the community. And frankly, there's probably no situation where that unfair inference is more prejudicial than in a sentencing case like this, where the issue on board is what should the sentence be, and should the defendant be released at any time in the near or even distant future. Of course, Lucci says that in these cases, the burden is on the state to disprove beyond a reasonable doubt that it was harmful. And that includes the implicit bias that comes with the use of a security device. Here, the record shows that the prosecutor, Mr. LaDucer, said that he didn't think that there were any facts upon which the use of a security device could be used or could be employed by the jail. Defense counsel objected as well. the court went through and listed off the factors, but somehow made a conclusion that there was some sort of danger to the people in the courtroom, again, at a proceeding that was not a hearing, and where Mr. Conley wasn't even allowed to be present so that he could interject objections or ask for the opportunity to address the court. So there's simply no way, based on that record, that either A, the use of the device was justified. Really, the only fact you have out there is the fact that he was charged and convicted of murder in the past, but that alone doesn't justify the use of a security device. After all, probably the leading case in this area is Deck versus Missouri, the U.S. Supreme Court case. And Deck, of course, was a case where the defendant had been convicted. It's a penalty phase shackling case. And so that alone does not get you to the justification. And then when you
Excuse me, Mr. Ellis. So the standard is abuse of discretion, right? And so the trial court kind of went through the factors, was concerned about courtroom security in a small courtroom. The judge could read the room. Obviously, you mentioned Mr. Conley had been convicted of a heinous crime. How do we find an abuse of discretion when this really is a discretionary type of decision?
Well, it has to be more than the simple ticking off of facts. I suppose the courts in Cowlitz County were concerned about people in the courtroom when they were routinely putting them in a cage in the courtroom, which is what Lukey struck down. The finding needs to be that not that the judge has some concern for the courtroom, but that the judge's concern has some basis in fact. In other words, that there is something that suggests that Mr. Conley is an imminent danger to those people in the courtroom. And the record here only had A, that he'd been convicted. That doesn't get you there. And then that was really rebutted by an agreement that Mr. Conley hadn't had any infractions in prison for decades. And so it's not, you don't exercise your discretion by simply ticking off the facts and not doing any analysis. There's no factual basis in this record where a court could reasonably conclude within its discretion that Mr. Conley presented a danger to anyone in that courtroom. After all, the court didn't even indicate he was in the courtroom. They could have all been Mr. Conley's supporters. The court didn't even go that far. But in terms of Mr. Conley's likelihood of acting out, there's simply no facts upon which a conclusion could be drawn that he presented any type of danger on that day. And that is itself abuse of discretion.
So talk about harmless error. So why, I mean, the judge obviously knows he's been convicted of this crime. Is there any indication that the fact that he was in a restraint had any impact on the trial court's sentencing decision?
Well, the courts recognize that the use of a restraint always implies a finding of dangerousness, a finding of imminent dangerousness. That is highly relevant to the sentencing decision. And it was made again without Mr. Conley present and without any facts. A judge who makes that determination, I suppose, could rebut that finding if he imposed the most lenient sentence possible. But where he imposes life without parole again, that is by its definition the prejudice.
Did the trial court mention dangerousness at all when she was imposing her sentence and going through the factors?
Well, the trial judge certainly makes a finding that the rehabilitation that and the evidence of rehabilitation that Mr. Conley presented was not compelling enough under the court's erroneous view of the law to overcome the presumption of life without parole. But the burden is not on Mr. Conley to show something in the sentencing that evidences prejudice. The duty is on the state to prove beyond a reasonable doubt not only that Mr. Conley wasn't prejudiced by the words and statements, but that there wasn't some implicit bias created by this. And I just don't know how you can do that in a situation where the judge makes that decision and then begins the sentencing hearing right after that, as soon as Mr. Conley is allowed the opportunity to appear in court, albeit with the threatened shock of a 20,000 volts, which would cause him to urinate and defecate on himself simply as the price of attending his own sentencing. And I think that's what Lukey says very clearly is we won't tolerate this unless there is overwhelming evidence that it's necessary. Very quickly, let me move to the Carter issue. Carter says the range is 0 to life without parole. Life without parole is not the presumptive sentence. There isn't any factor that needs to be proven in order to justify a sentence of less than life without parole. And so this is one of those cases where the standard, the legal standard that the court employed, I will grant you before Carter came out, turned out not to be at all the legal standard that now applies. And so if you compare the two, it's very clear that the court imposed an incorrect legal standard, much as the court did in the David Anderson case from Division 1, which was the state's appeal where the Division 1 remanded for a new sentencing, recognizing that the court had imposed the wrong standard. Like this case, Anderson was a case where the standard was announced after sentencing, but nevertheless demanded a resentencing. And with that, I know I'm running into my rebuttal time. I'll reserve the remainder for rebuttal.
Thank you very much. For the state?
Good afternoon. May it please the court. My name is Tom LaDuce. I represent the respondent, state of Washington. To begin at the same point regarding a discussion on the use of restraints in this case, I guess I'd first like to recite just quickly a summary of the law that begins, excuse me, with trial courts have broad discretion to determine what security measures are necessary to ensure the safety of the occupants of the court and maintain decorum. And the trial court abuses its discretion when its discretion is manifestly unreasonable or based upon untenable grounds or untenable reasons. Here, the court did engage, first of all, in an individualized inquiry and was aware of the requisite factors to consider. The court did not defer, like in Luthi, to a blanket jail policy. And first of all, counsel mentioned Luthi a couple times, and I've got additional comments to make upon that, but this was certainly in a different courtroom than the jail courtroom that had a holding cell that was really the focus or the crux of the issue in Luthi. So the court here did not defer to a blanket jail policy like Luthi or simply defer to Captain Lux's request, who brought this issue forward to the court. The stun cuff was actually a less restrictive alternative than the more visually obvious and constraining handcuffs and belly chains that the jail officer was asking for. Now here, the court had concerns about security because the defendant had been convicted of the most serious violent crime on the books, was serving a life sentence. The courtroom was packed, and I was there, and was obviously concerned that there was a risk that he might try to escape and therefore could pose a danger to individuals in the courtroom if he did so. And the state's position is that that was not manifestly unreasonable. It wasn't based upon untenable grounds or untenable reasons. The cases do not require some level of proof that the defendant has hatched a plot to escape. So, I think that's
Counsel,
important here.
Counsel, may I interrupt you? I'm sorry. I want to push back. I want to push back a little bit, at least hypothetically, on your point that this stun cuff was a lesser restricted restraint. The case law seems to indicate that it's a subconscious bias in the decision maker. That is the concern here, particularly in a non-jury hearing. Your opponent suggests that, that the consequences of 20,000 volts, if that's how many volts there are, would be more limiting in terms of the behavior of the defendant. And it seems like the implicit bias is there regardless of whether it's visual or not to a decision maker who knows that the restraint is there. What do you base, what's your response to that? That this particular device is actually far worse in terms of its impact on the defendant and neutral in terms of its increase or decrease of the implicit bias of the decision maker?
Thank you. So first of all, counsel just throws out that there's 20,000 volts. There's no record of that. I think in his briefing, he mentioned the use of a device in a case from the 90s where it was 50,000 volts. There's no record of that. We have no record to support these contentions of the voltage and that it would cause defecation or urination, or certainly that Mr. Conley, who was wearing the device, was aware of that and was inhibited in any way. Secondly, the courts, our courts have said that there is a presumption, and this is a key point, that there is a presumption that the trial court properly discharged its official duties without bias or prejudice. The other 2 points I want to make before I sort of launch into an argument is our courts have recognized the likelihood of prejudice is significantly reduced in proceedings without a jury. Secondly, that Washington courts have found the use of a restraint error was harmless where the defendant was not shackled in front of a jury because there is no evidence that that being restrained during pretrial proceedings prejudiced the judge against him during the pretrial proceedings, over the course of the trial, or at sentencing. And then again, where I started, there's a presumption against that the court discharged its duties without bias or prejudice. So consistent with those rules, since Mr. Conley was not before a jury, there certainly was no evidence, actual evidence, that the court was prejudiced against Mr. Conley, and there is a presumption that the court acted without bias or prejudice. Assuming there was error, the error is harmless beyond a reasonable doubt. Mr. Conley, there's no indication that Mr. Conley felt inhibited or unlike in Luthi, that there were obvious issues or concerns with his ability to communicate with counsel. This was a very lengthy sentencing hearing. Mr. Conley never had to walk like the various cases where it was arguable that a jury could have seen some form of restraints when a person got up to take the witness stand, or that sort of a situation. Mr. Conley gave a lengthy statement in allocution and in his presentation, indicating that he certainly did not feel condemned or was inhibited by the restraints. So that's sort of a long answer to your invitation to explain, but we certainly have no indication of the voltage or there's any indication that it impacted or inhibited him or communication in any way whatsoever. And again, I think the reliance upon settled law that a judge is presumed to be unbiased and not prejudicial and not prejudiced against the defendant applies in this case. So I cited the Lynn case. That's obviously, it was noted that Lynn was an unpublished decision, but I think it's helpful in here. There, Lynn was on trial for first-degree assault against the law enforcement officer and attempting to elude a pursuing police vehicle with an enhancement. He had substantial prior criminal history, multiple pending cases, theft charge, 2 warrants, and the court, even though the error was that the court acquiesced to the jail's request and evidently did not perform an adequate individualized inquiry, the court held, given this evidence, the court would have been justified in restraining Lynn on the grounds that there was a risk he might try to escape and could pose a danger to individuals in the courtroom if he did so. Accordingly, although the court failed to protect Lynn's constitutional right when it acquiesced to the jail's request, the error in that particular case was harmless. So I think what that case tells us is, contrary to counsel's suggestion that there has to be some sort of proof that rises to a level of an imminent risk, the circumstances in Lynn, the criminal history, the nature of the charge, led to an acceptable risk he might try to escape and pose a danger. So similarly here, Mr. Conley had been convicted of an extremely brutal crime, had been sentenced to a life sentence. The court noted that the courtroom was small, the courtroom was packed, which would certainly have added to jail's ability to thwart an escape attempt. And again, the state's position is that was not unreasonable. It's in line with the concerns expressed in Lynn.
So what do we do with the fact that you told the court that you didn't see any facts that would support a restraint?
Well, Judge, what I think there's a few things that you do with it. First of all, it's not my decision, it's the court's decision. The court has the discretion, a considerable discretion to maintain court security. I haven't been in that position, so I can't put myself in the shoes of the judge. When I approach a request to use restraint devices during a trial or a proceeding, I have already marshaled facts, I've written a memo, I've distributed the memo, and I'm prepared to make an argument in support of that, and I don't take it lightly. Here, we both enter the courtroom, that is Mr. Conley's counsel and myself. I have received no advance notice or heads up that there's a concern by jail staff. And based upon that circumstance, I'm not prepared to advocate for the use of restraints without doing the necessary legal research and ensuring that that's what I want to do. So, I mean, those were the circumstances that I found myself in. On the spot, I was reluctant to do anything but to defer to the court. And again, it was the court's responsibility, not mine, to maintain security within the courtroom. So that's my response to that.
Can we get to the sentencing? I guess we call it the burden of proof. I'm sure Mr. Ellis is going to address that on rebuttal. What was the judge doing here? It appears to me to be a blend of things the court is doing. in sentencing.
When
Go
the-
ahead.
Sure. At the sentencing hearing, we did not have the benefit of the Carter case. Okay.
Right.
So what we had as helpful authority was Ramos and Anderson. Those were similar situations where the court was dealing with the potential youthful mitigating factors, and the law going into that was very clear that that would have been looked at as an exceptional sentence, which under the usual rules under the SRA required the proponent to show by a preponderance of the evidence the existence of those mitigating factors. That was the only authority. Monschke did not give any guidance as to a burden or burden shifting or anything like that at a resentencing. So that's what the court had. But both counsel and the court recognized there was a dearth of authority on this. So first of all, it is unclear to me that Carter definitively resolves that. But really the important point is that in recognizing that it was, I'll put it this way, an open question as to whether the usual requirement that the proponent show by a preponderance of evidence the mitigating factor. In recognizing that, the court held in conclusion of law number 4, whether by a preponderance of the evidence or just an application of mitigation of factors, the court cannot find defendant's culpability was diminished as a result of his age and or applicable considerations of youth.
And so I said a blend earlier. Are they doing both? Is the trial court doing both here? As for sort of a, sometimes you've got two principles of law, you're not sure what's clear, so you cover both of them. Is that what's going on here?
I don't think it was, if I understand what you probably mean by a blend, I don't think it was a blend. I think the court.
I agree. I just retracted that part and said it's both. Sorry. I think it's both. I said blend earlier, but I think the court's doing both is what it looks like. And of course, I want to hear from Mr. Ellis, but if you could answer that, you can proceed, and then we'll get to the rebuttal.
I agree that it was both. I agree that somewhat like when a court announces several different reasons for an exceptional sentence, but further states that either reason standing alone would have justified the exceptional sentence. I think this is somewhat similar, that under either standard, either the preponderance standard stated in Ramos and Anderson, or by the standard advocated by Mr. Conley, the result would have been the same, that Mr. Conley's culpability was simply not diminished as a result of age or applicable considerations of youth.
So, counsel, I know you're going over. We're having you go over. I'm going to ask you a question, though, at the discretion of the presiding judge here. I just want to make sure I understand. Are you suggesting when the court said in conclusion of law number 4, whether by preponderance of the evidence or just an application of mitigation of factors, that second clause, is it your position that that's consistent with what Mr. Conley says is now required under Carter? That language evidences using 0 days to life as standard range. Is that what you read that language to mean?
I think by and large that sentence, that finding in conclusion of law number 4 was consistent with Mr. Conley's trial attorney's argument. And I think by and large, it is consistent with how Mr. Ellis views this particular issue. I think what may be missing is this idea of that it really came out in Carter was this range of 0 to life. I don't know that 0 to life was an obvious idea in this court's mind. But clearly, all parties were a bit struggling with the applicable standard pre-Carter, and recognizing that the court wanted to be clear in that it was even adopting Conley's position at the sentencing hearing, that there was no burden of showing the youthful mitigating factor, that she very clearly found that the culpability was not diminished aside from the burden of persuasion level.
Thank you, counsel. We'll switch over back to Mr. Ellis for your rebuttal.
Thank you. Well, I appreciate Mr. Ledoucer's candor that pre-Carter it was unclear exactly what the range of possible sentences were and what factors were relevant to a determination about what sentence to impose within that range. I will tell this court that I was appellate counsel in Monschke. I was appellate counsel in Carter. I was also sentencing counsel for Mr. Carter and for the co-defendant in that case, Ms. Righty. And we didn't know obviously how Carter was going to come out until Carter came out. There was obviously a great division of opinion in that litigation.
Let me ask you a question before you. Can you separate these two issues? The one being the burden of proof or not, and then the issue of whether a court knew they could go as low as 0 versus something other than LWOP.
Right.
So
and I think
less defined.
I think what's missing here is there is no affirmative statement that says I can go as low as 0, as high as life without parole. That's the range, and I can impose any sentence within that range for whatever reason I want to. Now, there may be some constitutional issues at the upper end at life without parole or de facto life, but there's nothing like that. Instead, what you have is this, and I think it's important to parse what the court said. First of all, it says that it's implying a standard of review, and the standard of review puts Mr. Conley in a position where he has to show something to justify a sentence less than life.
You mean burden of proof?
He has the burden of proof, but also that the starting point is life without parole. And in fact, if you go back to finding 5, it says the court maintains life without parole. In other words, Conley has not met his burden, one which he doesn't have, and we know that now. But because Conley hasn't met that burden, I'm just going to keep what was imposed previously. That's also the opposite of a de novo sentence. But what you have in the middle there is either this sort of Miller framework or this SRA mitigating factors framework, both doubled up. And the court says under either, you still haven't met this burden. Now, with regard to the SRA framework, one of the things that Carter makes clear is that the SRA doesn't apply in a Monschke class sentencing. In fact, the state, for reasons that I still don't fully understand, argued successfully in Ms. Righty's case that because the SRA has no application to aggravated murder, that they could not impose community placement or supervision on her, despite the fact that as Ms. Righty's attorney, I affirmatively argued for it and the court imposed it. But it's very clear in Carter and that portion of Righty that there is no overlap between the SRA and aggravated murder resentencing. And so even if you view this as the court adopting 2 standards, both are wrong. And both standards have to be read within that context of whatever Mr. Conley has to prove, he has to prove something in order for me, the sentencing judge, to vacate his previous sentence and impose a sentence less than life without parole. And again, I certainly appreciate the fact that the court was that Monschke didn't explain all of these things. There's no portion in Monschke that about what happens next, just that sentencings need to happen. And so for most of the Monschke class, they waited that 3 years until Carter came out before they went back for resentencing. Those cases like this one that went back for resentencing run the obvious risk that unfortunately materialized here, which is that the
Continue.
court, try as it may, imposed an incorrect legal standard when it imposed this sentence. And for that reason,
So let me, before you wrap up, let me ask you
Of
a
course.
question. So, you kind of say that the starting point isn't LWOP, but why isn't it? You know, and Anderson's a different case, but Anderson made it very clear that if you don't show that, or if the court doesn't find that, aggravating circumstances of youth, then you can impose, in that case, a de facto life sentence. Why isn't the same place here, that if the court doesn't find that the mitigating factors of youth are present here, then LWOP is a sentence?
Sure. Well, it's the range is 0 to life. That's what Carter says first and foremost. When you, as I mentioned earlier, approach the upper ranges, whether it's de facto life or life without parole, case law, at least the case law that's been defined that applies to juveniles, says that there have to be certain findings that accompany that. Permanent incorrigibility, or the lack of transit and immaturity. But there's nothing in Carter that says those things are necessary when exercising discretion within that incredibly wide range. You know, it's important to keep in mind that what Monschke does is it strikes mandatory life without parole as unconstitutional because there's an unacceptable risk given the group at play here, that children are different and children includes individuals up to age 21. But it doesn't impose, neither Monschke nor Carter impose some affirmative showing that must be made by the defendant in order to justify any sentence. Instead, the only showings that must be made in order to support a sentence are those showings that apply when a sentence is being imposed that's either life or de facto life. Although I'll say with candor again, that's been more focused on the juvenile cohort, which they've drawn the line at 18, and not necessarily the late adolescent cohort. Although, again, with candor, my argument is that those findings, that constitutional line needs to be extended to age 21, just as Monschke extended the Miller age to 21.
Thank you. Anything further? Nope. Thank you very much for your arguments.
Following these arguments, the court affirmed Conley's sentence. They concluded Conley did not have a right to be present at the restraint hearing, the court did not abuse its discretion by requiring Conley to wear the stun cuff at his resentencing hearing, and that the court did consider mitigating factors when sentencing him. They also concluded that the discretionary life without parole sentence is not prohibited by the Washington State Constitution. What do you think about this case? Is life without parole for young adults appropriate for such crimes? Let me know what you think in the comments below. And if you like this video, please hit subscribe for new arguments every week.